The submissions which are also...
So you introduce yourself, because these are recorded, we no longer write notes.
My name is Otiende Amollo. I appear with Bryson Umeto for the third petitioner in petition number 181 and for the petitioner in petition number 219. The substratum of the petition and the submission file is that the Finance Act challenged here has various procedural and substantive instances of unconstitutionality. And cited instances of infractions of fundamental rights. Now, we will only highlight about 5 quickly because we submitted on most of them. Number 1, starting with the housing levy captured in section 84 of the Act. It is our submission that this section purports to amend the Constitution. It purports to amend Schedule 4, Part 1, Part 2, Clause 8b, which exclusively gives the jurisdiction of housing to counties. The only leeway left for national government under Part 1, Clause 20 is housing policy. In purporting to create a levy and giving jurisdiction to the Cabinet Secretary to administer it, the Act is purporting to amend the Constitution, which cannot be allowed. And it's unconstitutional to that extent. The respondents seek to avoid that by saying that it's actually not a levy, it's a tax under Article 209. 1. Lord, that does not answer the substantive issue of where the jurisdiction lies. By whatever name called, you cannot amend Schedule 4. In any event, my Lord, being taken to 209 can only serve the respondents adversely. For Article 209 is very clear on the kind of taxes that can be imposed. And it does not include such a tax as a housing levy or a housing tax. It is our further submission that it's unconstitutional to collect any form of tax, or in this case levy, without a foundational statute. You would have to establish, you have to create a statute to establish a housing fund, then you can collect such levies. That has not been done. I ask you, my Lord, to take judicial notice that in fact, having realized that anomaly, the respondents are only now trying to remedy that anomaly through a bill that is yet to be passed, the Statute Law Miscellaneous Amendment Bill 2022, which is yet to be considered by Parliament. And also you will note that at clause 83, they now seek to bring clauses that will bring definitions and a foundation for the levy. It is our further submission on that issue that so-called housing levy is discriminatory insofar as it only targets common employees and employers. That runs counter to Article 27. And to the extent that it is a mandatory contribution, it amounts to servitude and offends Article 30. The last submission on that, my Lord, is that they have sought to compound that illegality and unconstitutionality by requiring the Kenya Revenue Authority to be the collector of that levy. Under Section 5 of the KRA Act, Kenya Revenue Authority has no such authority unless introduced by legislation to collect this kind of tax. What they can collect is restricted. We invite my Lord the ladies to take note that this particular limb of the petition has not been answered by any of the respondents on the unconstitutionality of bringing a county function to national government. Our second limb, my Lord, your lady, is that the Finance Act, now challenged, introduces 22 new provisions out of 84. 22 new provisions that were not considered at the first reading, not considered at the second reading, and were not subjected to public participation. This constitutes 25% of the entire act. Our simple submission on that respect, my Lord, is that that scheme of things offends Article 201A of the Constitution that requires openness, accountability, and public participation. The respondents, especially the National Assembly, does not contradict that assertion. Their submission is that is a matter of the internal workings of the National Assembly, and the court should not interfere. We submit, my Lord, with respect, that there is a good reason why the Constitution, the statutes, and the standing orders require that these processes be undertaken. And public participation is not internal to the National Assembly. My Lord, my lady, limb number 3 is that, my Lord, before I leave that, the totality of the new provisions are captured in paragraph 64F of the amended petition. They are all outlined. My Lord, the third submission is on the scope of the Finance Act. Our submission, my Lord, is that this Finance Act 2023 includes matters that are outside the ambit of a Finance Act. And also outside of the ambit of a money bill under Article 114(1) and 3. Article 114(1) and 3 as read with Article 209. My Lord, we have outlined the Finance Act as captured, and the intention of any Finance Act, as with this, is an act of Parliament to amend the laws relating to various taxes and duties. Taxes and duties is always the ambit of a Finance Act. As we have demonstrated, my Lord, this Finance Act has matters as if it's a statute miscellaneous amendment act. It covers a range of things, from talking about benefits of a retiring deputy president and speaker, section 92 all the way to 98. It covers issues of at what stage should a statutory instrument expire in section 89 and 88. It covers such things as the constitution of the Kenya Roads Board in section 78 and many others. My Lord, it is not open to the National Assembly to introduce everything and anything under the guise of the Finance Act, because the Finance Act has special protection for good reason. Such things can only be introduced in a Statute Miscellaneous Amendment Act, not the Finance Act. And to the extent that it has introduced all these strange things, it ceases to be properly a Finance Act as defined in law. More importantly, my Lord, it then has a very serious result, and the result is it ceases to be a money bill under Article 114 of the Constitution. My Lord, you will hear later why the Senate should have been involved. But the limit of this submission is once you introduce matters that are outside a money bill, then that bill ceases to be a money bill and ceases to have the protection in Article 114. In which case, it must get the concurrence of the Senate. My Lord, that point has been prosecuted in the Court of Appeal successfully, and in our submission in E181, paragraph 29 of our submissions, we cite the case of the Speaker of the National Assembly and another versus Senate, where the Court of Appeal said that while a money bill is protected, there is one caveat, however, under Article 114(1) of the Constitution. A money bill may not deal with any other matter other than those specified in the definition provided at Article 114(3) of the Constitution. The implication being that the inclusion of other matters in a money bill would remove it from the purview of Article 114 of the Constitution, with the effect that it will no longer be enacted in accordance with the procedure of enactment reserved for money bills. The ambit of that, my lords, my lady, is that having then included all these other matters, then it became important and necessary that the bill goes through the process that any other bill would have gone through, including the Statute Law Miscellaneous Amendment Bill. It is therefore not open to the respondents to say this is a money bill and it's protected by Article 114. My Lord, number 4, and of this I will not emphasize, I'll only mention, it is our submission that the Finance Act, insofar as it was passed by the National Assembly without the input of the Senate, therefore runs contrary to Article 110 on the question of concurrence on bills concerning counties. I will let the first petitioner and my brother Senator Mugeni submit at length on that. It is our further submission, number 5, my lords, that zeroing in on section 33 of the Act, which seeks to charge VAT on insurance compensation, we submit, my lord, that this is an infraction of Article 40 in terms of protection of the right to property. For compensation for loss in insurance is just that. It is restitution to where you are. You will not have purchased any goods or rendered any services. And in fact, there's no value addition that ought to be taxed. And seeking to tax this, therefore, is improper and offends the right to property under Article 40. It is our further submission, number 6, my lords, my lady, and it's captured in our submission, that in terms of procedure, there was a fundamental error that we did in the National Assembly, and that we failed to follow the provisions of the PFM Act and our own standing orders. Our submission, my lord, is that, as expressly stated in those provisions, the finance bill ought to have been presented on the same day, at the same time, with the budget policy highlights. That is the gravamen of Section 43 of the PFM Act and Standing Order 244C, Clause 4. We ended up with a situation where we passed the bill, then came to discuss the budget later. It is our submission that there's good reason where they are to be presented together, so that the discussion on the budget can precede the act. And this was not done. Various explanations have sought to be given by the respondents for that, but they all belong to the realm of speculation. My lords, my lady, I have only given the outline because many of these will be submitted at length by various petitioners. But I want to say this. As petitioners, we look to you as the bastion, as the last bastion and bulwark against creeping disregard of the Constitution and the law. If my lord looks at the response by the second respondent in 219, my lords will see that we as an institution of parliament have become more executive than the executive itself. I am saddened to admit, my lord, that when it comes to observance of the Constitution and checking on the executive, the judiciary becomes the last bastion. It is of no consolation that we have independent offices and constitutional commissions. Because, my lords, as is evident, these two have been browbeaten to submission. My Lord, we look to you and we look to this court to demonstrate that while it is entirely for any particular regime to determine its policy priorities, entirely for them, those priorities and the way of determination must be within the law. My Lord, this petition is not about the choice of priorities. This petition is about whether the law has been followed. We have gone through what I would only call various epochs in judicialism. From 3.5 decades ago, my Lord, when the Honorable Professor Wangari Maathai was described as a busybody in 1989, and the lawyers representing her, fairly eminent, were castigated. We have come full circle, my Lord, to where these courts have had the courage to nullify presidential elections. Where these courts have had the courage to tell a sitting president in the BBI case that you are wrong. And I was on the other side of receiving that. But I'm happy that the court would have the courage to tell the chief executive and the executive generally when they are wrong. So should it be when it comes to the National Assembly, when it comes to the Senate and any other entity. My lords, my lady, as I close, we look forward to this court robustly examining the issues at hand without accepting the fear-mongering that you will hear from the respondents on the consequences of nullification of the act. Lord, we look forward to this new epoch where public-spirited individuals are complimented, not vilified. We submit, my Lord, that once you retire to examine the totality of our submissions, we invite you to find the whole of the Finance Act 2023 as null and void. In the unlikely event, my Lord, that you find it necessary not to avoid the whole of the Act, we still invite you to nullify all those parts of the Act that are clearly unconstitutional and an infringement of fundamental rights. My Lord, I have exceeded my promised time by 2 minutes only. Thank you.
Mr. Mtata.
Is there a mobile mic? Oh, yeah. We can move for it.
Microphone.
Can you know what we can do, my Lord? I think I can create space so that because I realize there's limited resources.